Now, the next topic that we want to look at to introduce this concept is the notion of uniformity. Businesses prefer a strong legal infrastructure. When businesses look to go abroad, to do business abroad, they prefer to work in countries that have a strong legal infrastructure. And there's really two reasons for that. And the first is clarity. Clarity, knowing what the law is, knowing what a company can do, as well as what a company cannot do. So businesses prefer clarity, a legal structure that provides clarity, clearness. Now, the other thing that businesses like is predictability, meaning once the law has been applied, that law should be applied in the same or similar manner for all similar situations. So clarity and predictability are the things that a company, that a business desires when deciding whether or not to do business in a foreign country or with a foreign entity. Now, the less differences in the laws between two nations, the better it is for business. Businesses also like uniformity. If the law in China governing the sale of goods is the same law as applies in the United States for the sale of goods, well, you can see that from a business perspective, that is a huge advantage. That provides that predictability. Knowing what the law is in one nation is the same as knowing what the law is in other nations that have joined into the same treaty. So businesses like uniformity, obviously. And in fact, it's business that has driven certain uniform movements. Businesses are what drove the adoption of the Convention on Contracts for the International Sale of Goods. Businesses have driven the growth of international arbitration, which we'll take up in a later lecture. And the reason why is that businesses like uniformity. And in fact, international law has become more uniform in recent years. And the reason why is free enterprise, free trade, globalization. They've all increased the need for uniformity. And therefore, nations have responded to the pressure of international business to create uniform laws, to create uniform standards. They have had to cooperate in their response to global issues. So when a company in China wants to do business with a company in the United States, and the legal infrastructure is different between the two, then both the Chinese company and the United States company will appeal to their respective leaders to provide that uniformity. People want to do business. People recognize the opportunities abroad. And matter of fact, this has been pretty much the standard for the last 30, 40 years, this notion of free trade and globalization. Now, fortunately, international organizations have also stepped up, and they have provided codes on certain business subjects. And these business subjects, again, the International Organizations Code may not be law, but if two businesses treat it as the governing standard, then it has the same effect. We've also seen a growth in international dispute resolution. Again, we'll take this up in a later lecture, but the fact that disputes are now litigated or resolved in these international forums have driven uniformity. Why? Because both nations can assert what they believe the law is, and the international tribunals can set out their own interpretation of the law, and that can be made available to other tribunals as well. Finally, we've seen private industry organizations, trade organizations have also encouraged the growth of international business law for those same reasons, that where there's a need and neither a government, a state, nor an international organization has provided a governing standard, well, perhaps a private group advocating a standard is enough to establish what the standard should be. Now, having acknowledged that international business law has become more uniform, we also have to respect the differences and know that international business law still retains much of its national characteristics, its domestic national characteristics. And the reason why is that in litigation, national courts will interpret and apply international business law according to their own legal rules and according to their own precedents and their own legal histories. So even a uniform body of international law can start to diverge because it's being enforced by a national court. A national court is going to bring its own unique legal culture to the decision, to the resolution. Now, differences in national legal systems reflect different legal approaches to business law. We'll see, for instance, that in Europe, a potential remedy for a breach of contract is called specific performance. Require a company to obey the terms of the agreement. In the Anglo-American system, in a common law system, specific performance is only rarely awarded. Instead, we prefer money damages in its place. So even if we had a body of law providing for the standards of conduct, when it comes to a remedy, a European civil court may look at the question differently than a domestic United States federal court. They would have a different backdrop to what the remedy should be. Also, the level of socioeconomic development in a country can greatly affect its legal culture. Its legal development can be dependent on economics. So lesser developed countries may have a lesser developed legal infrastructure. And again, even though it's applying the same body of law, a uniform or supposedly uniform body of law, because it's a less developed legal infrastructure, we may see a different result from it. The fact is that national attitudes toward economics can also affect law and regulation. If a country has an outlook that is different in terms of things like socialism, then we're going to see different results in the legal infrastructure. So just for this short lesson, let me reiterate. International business law is that body of law that governs cross-border transactions. International business law has become more uniform in recent years. Nevertheless, international business law retains its national character.